We are very, very privileged today to have Ambassador Stephen Rapp with us to speak to us about the Katyn crime. I first met Ambassador Rapp when he was a prosecutor at the Rwanda Tribunal many years ago. He later became the chief prosecutor of the Special Court of Sierra Leone, and his predecessor, David Crane, is here as well. And in just a couple of weeks, on March 15th at the City Club, we're hosting Brenda Hollis, who's the current prosecutor. So we're doing a lot of prosecutors of the Special Court for Sierra Leone. All of them have worked on one of the most unusual and interesting cases of all time. It's the former president of Liberia, Charles Taylor, and that trial is coming to an end imminently. In 2009, Stephen was appointed U.S. Ambassador at Large for War Crimes Issues, which is an extremely important portfolio in a world where crimes against humanity, genocide, and war crimes are occurring across the globe. That summer, I happened to have been in the Netherlands. We were setting up a new MOU, a relationship agreement, with the newly created Special Tribunal for Lebanon. And I was trying to convince them that they want us to do research assistance for them the way we had done for other tribunals. And Ambassador Rapp was just going around and introducing himself to the new prosecutors and their staff, and he happened to pop in when I was in the meeting with the prosecutors, and he said, "Michael, what are you doing here?" And I said, "No, I'm not leaving academia." I explained to him that I was trying to set up a relationship like the one I had done for him. And I have to tell you, the Lebanon Tribunal is ultra secret, and they were skeptical about having an academic entity help them out. And we are, Case Western, the only academic entity that they've reached out to. And the reason that happened is because Stephen, with a huge assist, said, "You all need to work with Michael Scharf. I trust him. His group at Case Western produces great stuff, and you need to take advantage of that." And I really appreciate that, and I can never thank you enough for that. The things that are coming out of the Special Tribunal for Lebanon are starting to become very exciting. This summer, I got to see Ambassador Rapp in action once again in his environment. It was at the ICC Review Conference in Kampala. I was representing an NGO delegation, and this was a really tough thing for the United States. The Review Conference was debating whether they should add the crime of aggression to the ICC statute, and the U.S. policy was to oppose that. And the U.S. did not, however, want to be seen as the skunk in the room. And that's a really hard thing to do. And so Ambassador Rapp gave a speech, which was totally amazing. I have said publicly that it was sort of a Kennedy-esque Ich bin ein Berliner moment. He told all the people in the room that he had spent all these years as a prosecutor working for these international tribunals, that he was an ICCer. And then he proceeded to tell them why it might be a mistake to add the crime of aggression. But it was received so well because they knew he was one of them. They trusted him, and they trusted his word. And we are very fortunate to have him with us today, and I hope this is the first of many times you'll come to Case Western.
Okay. Thank you. Well, thank you very much, Michael, and also thank you for what the Cox Center and all the students at Case Western Reserve School of Law have done for international justice and for the continuing work of the tribunals. It's been fantastic. Thank you also for saying that I'd be providing the lunch entertainment, and I'll try to do that. Though, of course, these are very, very serious topics and challenging ones, but ones that have provided me with the greatest satisfaction in my life, despite the challenges and frustrations that one faces in establishing justice. I wanted to contribute to this discussion in a way following up on what my good friend John Barrett began in the morning panel in describing the Nuremberg Tribunal, to be followed by what Bill Shabus will say on the next panel, to discuss Katyn in light of international justice and what the handling of that crime at Nuremberg and what the results of that process have meant in the development of the tribunals that have followed and the demands for justice that are with us today. The lessons that we can draw for the project of criminal justice. And I'll speak from the perspective of an ex-prosecutor. I was a prosecutor in the United States for 8 years as a United States attorney, as a chief law enforcement officer in my home state of Iowa before I went out to Africa 10 years ago and worked in the Rwanda Tribunal, first as a senior trial attorney prosecuting in the actual trials day after day, and first in the media trial. It took 34 months to convict those who had incited the genocide through the mass media and through a newspaper, and obtaining a conviction similar to that obtained against Julius Streicher at Nuremberg, but now because of the crime of genocide, also for genocide through the mass media and direct and public incitement through messages of the mass media. Thereafter, I became the chief of prosecutions at the Rwanda Tribunal, and I want to distinguish that that is not the top job. I was under Carla Del Ponte initially when she was prosecutor of both the Yugoslavian and Rwanda tribunals. That changed in September of 2003, where the jurist Hassan Jallow of Gambia became prosecutor of the ICTR, the Rwanda Tribunal, and promoted me to the position of essentially the supervisor of all the trial teams. And I was honored about 3 years later to follow my good friend David Crane, who's here today, as then the chief prosecutor of the Sierra Leone court. Now my position, since September of 2009 as ambassador at large, working directly under Secretary of State Hillary Clinton and working for the administration of President Obama, is to work on our American policy toward and in support of systems of accountability for mass atrocity across the globe. Other speakers today have spoken of the crimes at Katyn. We know a great deal about those crimes. We know that at least 21,857 human beings were murdered in cold blood based upon an explicit and direct order signed by Joseph Stalin, co-signed by 5 other individuals, some who survived him, one at least, Anastas Mikoyan, who continued in the leadership of the Soviet state into the Brezhnev era. We know that this was part of a pattern of crimes committed against other individuals occupied by the Soviet state. We also recall, as John Barrett has so clearly laid out, how this issue arose during the course of the most important trial that followed World War II. There were, of course, many trials, but the most significant that we all remember, and the most historic, and the one in which we joined with our allies in the defeat of Nazi Germany, with the government of the Soviet Union, with the government of France and the government of the United Kingdom, was at the International Military Tribunal, convening in The Hague from November of 1945 until it rendered its verdict on the 1st of October, 1946, and in which our own Associate Justice Robert Jackson, served as the chief U.S. prosecutor. There is, I suppose, the concern that in that trial, we had individuals among the other prosecutors, among one of the judges that had the power to sign the order and his alternate individuals appointed by the regime of Joseph Stalin, complicit as it was in those crimes. And we've heard of the fact that within that indictment, a false allegation appeared, not considering the other crimes committed and alleged against the Nazis, a major part of the allegation against the Nazis, but it appeared nonetheless. How do we react to that? And what does that cause us to think about the Nuremberg legacy? One of the greatest honors that I've had, I don't know if I'll ever have another, that moved me quite so much, was the opportunity to represent the United States of America. Now, I guess it's about 3 months ago, on the 65th anniversary of the opening of the Nuremberg trial. It had opened on 21 November, at least with the opening statement of Justice Jackson, and on November 21st, 2010, the city of Nuremberg had finally decided to build a museum in the attic of the courthouse to open for public exhibition Courtroom 60, which is an active courtroom where current trials of ordinary crimes are tried in Germany, but to open that on a regular basis to the public. And on that occasion, aside from the officials like the Foreign Minister of the Federal Republic of Germany, the representatives of the 4 Allied powers that tried those at Nuremberg, the 22 Nazi leaders in the International Military Tribunal, were invited to send representatives. The Russians sent their foreign minister, Sergei Lavrov. President Obama sent myself, the ambassador at large, for war crimes issues. And it was an occasion for me to talk about the historic importance of that trial. And many speak of it in different terms of what the Nuremberg legacy meant to them. But I quoted in particular the words of that eloquent opening of Justice Jackson, 65 years to the day before my speech, that said that the law shall not stop with the punishment of petty crimes by little people. It must also reach men who possess themselves of great power and make deliberate and concerted use of it to set in motion evils which leave no home in the world untouched. The great principle that no one is above the law. I said that day, and I was speaking in front of a German audience, and so I searched and found a quote from Goethe. And in speaking of the significance of what happened on November 21st, 1945, I compared it to what Goethe had said about an event that he had been an eyewitness of, the victory of a citizen French army, over the armies of old Europe, of imperial and regal power in 1792. As he said, from this place and from this day forth began a new era in the history of the world. I believe that, and what was accomplished at Nuremberg, with its flaws, continues to resonate. John has talked specifically about the allegations and the indictment and how they were handled. And we've heard, of course, of the testimony of Justice Jackson himself in 1952. I, as a prosecutor, am always reminded, because I hear it constantly in court, I heard it when I was a prosecutor of ordinary crimes, that accused will come to court and say, other people committed crimes. Why aren't they here? How dare you try me when there's guilty people out in the world? And except in very exceptional circumstances, that's no defense. It's no defense if we're picked up going 80, that somebody just passed us going 88. It's no defense that others have murdered when you bring a murderer to trial. The lesson of Nuremberg, however, is now resonating in international tribunals, those in which I and David Crane and Michael and his students and others are involved. And it resonates in tribunals that began to be established after the end of the Cold War, with the horrendous atrocities that began to occur in places like the former Yugoslavia, or in Rwanda and elsewhere. Not that horrible atrocities hadn't occurred in the 45 intervening years, but they're ones of, to some extent, because of the forces then unleashed, that were dreadful and unimaginable. And courts were created, first by the United Nations in regard to Yugoslavia and then Rwanda, under the authority of the UN Charter, which allows the Security Council, when it acts without a veto, and there was, unlike the situations where if justice were pushed earlier, not in the Soviet Union or even in China, a desire to veto the approach to these particular issues. It allows the Security Council, acting in the interest of world peace and security, to take action that's binding on all the states of the world, and to fashion remedies that will prevent future outbreaks that will affect peace and security. And so, in what many considered unprecedented in terms of how it was done, but not a whole lot different than what the four allies did in London with Justice Jackson, a Yugoslavian Rwanda tribunal were established by resolution of the Security Council. Those courts, however, dealt with only part of the mandate, I should note, of Nuremberg. Nuremberg, as we've heard, had 4 counts in the indictment. I'm talking about the IMT trial. There were the first 2 counts that dealt with conspiracy to wage an aggressive war and waging an aggressive war, crimes against peace. The 3rd and the 4th counts were war crimes, crimes against people in the occupied territories generally, or individuals that were no longer in combat, and crimes against humanity. And the tribunals in the Security Council and establishing those tribunals reached back to Nuremberg and took language directly from the Nuremberg Charter in deciding what could be prosecuted. In that regard, I might just speak a short footnote because Michael has brought up Kampala and the crime of aggression, but I think it's important to note that no court yet has, since Nuremberg, the power to prosecute the crime of aggression, but it's something that's being debated in the context of the revision of the ICC statute, which occurred at this conference that lasted for 2 weeks in Kampala in Uganda and Africa, in which I was co-leader of the United States delegation, a position, the United States role in the ICC is, of course, not yet and not contemplated a ratified member of the ICC, but we're entitled to participate as observers, to speak and not to vote. And beginning with the Obama administration's decision in November of 2009, we've been doing that. But of course, at Nuremberg, it has to be remembered that while aggression, the Nazi plan to launch an aggressive war in Europe was a major part, and indeed to some extent a dominant part of the evidence in that case, there was, like Katyn, also a part of the case where there wasn't a charge against a party obviously guilty, and that concerned the aggression against the Polish Republic, against the Baltic republics, and against Finland in 1939 and 1940 by the Soviet state. That wasn't part of the case. Of course, the question of whether one can criminalize aggression, which involves complex issues of what territory is whose territory, and how one is justified in hot pursuit against rebels, and where borders are drawn, and the sort of political issues that arise there, and the difficulty of dealing with that is one of the challenges that we were facing in Kampala and will continue to face. But the legacy of Nuremberg stands out so solidly and is followed so clearly by these tribunals when it deals with atrocity crime. And by atrocity crime, we're referring to crimes where the innocent are intentionally targeted, not crimes of mistake in combat, not crimes of collateral damage, as painful as the injury or the deaths may be to the victims, but involve situations like a genocide, like a crime against humanity, which is a widespread and systematic attack against the civilian population, and the individual crimes committed as part of that, the murder, the extermination, the rape, the imprisonment, the mutilation, or war crimes, which involve generally attacks against civilians or individuals that have laid down their arms. Those are the crimes that, upon which the world is unified. Indeed, the statute of the ICC which was adopted in 1998, which the United States, as I said, has not ratified, reflected an American proposal on how to define those crimes and was absolutely unanimous, so that the code of genocide, war crimes, and crimes against humanity is, in a sense, universal law, and that's what these tribunals have been doing. The principle of Nuremberg has resonated in the prosecution of atrocity crime, involving bringing major perpetrators to account in these later tribunals. Senior military leaders, militia leaders, persons who have great power within a state, as we had in Rwanda, not just the government, but also business leaders, also media leaders, also, in that case, even members of the clergy have been charged. But even people at the highest levels, the Rwanda Tribunal has brought to trial more than 12 former government ministers, convicted the prime minister of the genocidal government of the crime of genocide and sentenced him to life. The ICTY, the Yugoslavia Tribunal, famously prosecuted Milosevic, sadly, who died just before his case would have ended, prosecuted the leaders of Republika Srpska, like Radovan Karadzic, whose trial is ongoing at the moment, and of course, as David Crane and I know so well, that Charles Taylor at the Special Court for Sierra Leone has a case that is now set to conclude, and I'll be in The Hague on Tuesday to watch, this time not to participate, but to watch my former team essentially present the closing argument in that case and send it to the judges for a decision expected in the next 6 months. The theme of all of this is the end of impunity for atrocities. And the hopes are two. One, that we signal to those that would commit these crimes the possibility, at least, that they'll face consequences. Criminal law is always imperfect. We know that even the most effective and well-financed and professional of law enforcement and justice mechanisms don't guarantee us that all crimes will be deterred or prevented. But by prosecutions, by holding guilty people to account, we do deter crime. We do make it possible for us to live lives that are not nasty, brutish, and short. And so it's an important aspect of this process that even though it doesn't cover every country, even though it doesn't cover every situation, that it creates in the back of the mind of anyone that may commit or consider committing these crimes the possibility of facing justice, and add a factor that may discourage the commission of atrocities. There's also, of course, the hope of reconciliation. The hope that by bringing forth the truth, by recognizing that some people committed horrible crimes and other people were indeed victims, and by honoring that victimhood with a condemnation of those responsible, we make it possible for societies to reconstruct, for people to recognize that it's not everyone of that ethnic group that committed those crimes. There were leaders and others that made it happen, and that people as human beings across ethnic and religious boundaries can begin to build ties and to strengthen ties of common humanity and prevent the crimes from occurring again. And that's important because as we look at history, I always noted the irony that some of the worst crimes are committed by people who were into a mentality of victimhood. That Milosevic, famously at the Field of Blackbirds in 1989 in Kosovo, 600 years after the glorious defeat of the Serbian people by the Serbian state at the time by the forces of Ottoman Turkey, spoke of the victimhood of 600 years of Serbian people, obviously a victimhood compounded by the victimhood during World War II. And that gives to some a sense that the children of those who committed those crimes, be they Turks or now distantly related Muslim Muslim groups or Croats or Bosniaks or others bear some part of that crime and justify in some way action against them. In Rwanda, I had John Bosco Baragwiza, whom I convicted in the media trial, and he had given an interview on his own radio station, RTLM, which the judges found was not in and of itself an incitement, but he described 9 generations of oppression of the Hutu people by Tutsis, and spoke of the fact that, if the RPF took over, that oppression would return. And this is why, in large part, it's important to recognize that as one prosecutes crimes, there will often be a feeling on the part of even the group whose soldiers, whose militia committed the greatest offenses, that their suffering is not recognized. And this comes up in this whole issue of whether it's important in a tribunal to prosecute both sides. And there's a resonance from Katyn in that. And I want to be careful because there's a distinction, and a very important one. But there are similarities to how these issues arise. The victims of Katyn, the Polish state, the Polish people, entirely innocent. This is not a question of both sides in some kind of war between Germany and Poland. But there is this aspect of the Russians having, after the invasion of 1941, become a major part of the alliance to destroy the evil of Nazism and the loss of 20 million Russians in the course of that campaign, and the sacrifice and effort without which it would not have been possible to defeat the evil of Hitler and the Nazi regime. And so quite often in these cases, you have people come forth and say, we fought on the side of the angels. How dare you come in and prosecute any of us? Because, of course, in a war, horrible things will happen. And on the other side, you have people who say, as Baragwiza did in his book published before we arrested him, is Hutu blood not red? Do our victims not count? How even-handed should international justice be? Nuremberg is accused of being victor's justice. No Allied soldier, leader, faced any consequences at Nuremberg. And the international tribunals, in a few cases, are also accused of essentially victor's justice. Things have changed, and procedures, as these tribunals have been established, are different than they were at Nuremberg. If we tried Nuremberg today, tried those Nazi accused, there would have been obligations to provide all the exculpatory evidence in U.S. files, everything that we had about if we had it or if others had it and we had access to it, would have had to be disclosed to defense teams. In every case that I faced in tribunals, defense attorneys often went on at greater length than they did about the innocence of their clients about crimes committed by the other side. Judges generally finding that wasn't relevant. The cases, the ways in which these have been approached by the tribunals, I think to some extent follow lessons learned at Nuremberg, and the example of Katyn, the example of a crime unpunished, continue to resonate. At the International Criminal Tribunal for former Yugoslavia, Carla Del Ponte, Louise Arbour, and particularly Carla Del Ponte, as chief prosecutors, made a point of trying to prosecute all sides. I think in the case of the ICTY and the ethnicities of the former Yugoslavia, only the Slovenians for whom the war ended in a few days have escaped indictment. There have been Serbs from Serbia and Serbs from ethnic Serbs from Croatia and Bosnia. There have been Bosniaks, in other words, Bosnian Muslims. There have been Bosnian Croats. There have been Croatians from the Republic of Croatia. There have been Kosovars, members of the and leaders of the Kosovar Liberation Army. There have even been, though the number of victims is very small, defendants from Macedonia. And in doing this, Carla, and I have not talked to her about it, I've read her book, was doing it in reflection to a large extent from the fact that as she went to the former Yugoslavia and talked to various groups, they'd say, what about us? What about our victimhood? And you hear that most commonly from people of Serb ethnicity. And if you count up the victims, the number of allegations against ethnic Serbs is far greater. The number of accused that are ethnically Serb are far greater. What about the crimes against us? I was in Vukovar on the 19th anniversary of, this year I've made a tour of these sites. I was at Srebrenica on the 15th anniversary of the 8,000 men and boys being killed there for a commemoration. And on the 19th anniversary of Vukovar, when almost 300 innocent and wounded Croats were taken out of a hospital, even while the UN was watching from the front door, and taken out and executed. There was a few miles away a crime in which a score or more of ethnic Serbs were killed by a Croat force. And so the issue is, shouldn't you prosecute both sides? I think an example of how this can be carried forth is also to be recognized in the way in which Prosecutor Del Ponte chose to respond to the NATO bombing. As you recall, in 1999, the United States, with its NATO allies, but without UN Security Council approval, in order to stop Milosevic from the ethnic cleansing of Kosovo, in which hundreds of people were being murdered and tens of thousands of people were being pushed toward the borders, launched a military campaign which included the bombing of Serbia and Kosovo to stop it. It was an operation that went on for more than 80 days and in the end succeeded. At the end of that time period, however, Prosecutor Del Ponte said, did Americans commit crimes? And you can imagine that didn't go over well in NATO and in the United States. She appointed a Canadian lawyer of a background that came from an experience in military justice, Bill Fenwick, who analyzed every case in which civilians have been killed, like in the Chinese embassy and in the Serb radio station and on that railroad trestle and everything else, and filed a public report indicating that the threshold for war crimes had not been crossed, that these had not been intentional crimes, that the weapons that were used were proportionate, that these attacks involved military targets justified by military necessity, that there was a distinction between civilian and military targets that was observed. But if you read Carla Del Ponte's book, she says at the end of it, I made a mistake. I should have prosecuted the United States. It would have looked good to have one of those cases also. It would have shown my even-handedness, and spoke of a judge saying to her, you should have prosecuted an American. Now, obviously, any system of justice has to be prepared to see the prosecutions of one's own. But in that situation, I think we see that there's the danger when a prosecutor moves out and says, I'm going to try to punch every button. Because, of course, what we're talking about here is grave atrocities. We're talking about tribunals that need to focus their attention on the intentional crimes, on leaders that made the decision to target the innocent. And so I think even while there's pressure for the point of view of reconciliation to move to both sides, to all sides, and to try to find something to nail on everyone, I think the lesson of what happened in the former Yugoslavia is that it doesn't work. On the other hand, what's happening since the tribunal has begun to close, and as it's been transferring cases back to the region, And as the prosecutors have been working with local authorities, the number of cases now being made in Serbia against Serb accused for crimes against others, in Croatia for the same thing, and to a lesser extent in Bosnia are out there and occurring. There are other tribunals and other experiences. I could talk a great deal about the ICTR and the Rwanda Tribunal and the criticism that it received for not having prosecuted, at least in Arusha, the alleged crimes committed by the RPF, the Tutsi-led group led by Paul Kagame that stopped the genocide of 800,000 Tutsi, generally Tutsi, but also moderate Hutu who were trying to protect them. The 800,000 killed in the Rwanda genocide by a Hutu extremist government. Those individuals who were attacked weren't protected by the UN or anyone else. A Tutsi-led force essentially defeated the Hutu extremist government and ended the genocide. But it's alleged that in the course of that, 30,000, at least 30,000, as my late friend Alison DeForge has indicated in her book, targeted killings of Hutus were committed by the RPF. And the failure in that case to prosecute that crime continues to haunt the legacy of the ICTY. At the Special Court for Sierra Leone, my predecessor David Crane, and this was in a court where at the time these prosecutions occurred, there was a UN peacekeeping force in country, something there wasn't when the ICTR was there, and where any sort of case against the Rwandan government would have been a challenging one. But I think courageously, and I was proud to follow up and move ahead with convictions in these cases, chose to prosecute both sides in the conflict in Sierra Leone. A very controversial decision because everyone in the world knew of the fact that Hutus, that the RUF had committed these atrocious crimes of rape of hundreds of thousands, of murder of tens of thousands, of amputation, cutting off of hands and arms of thousands of individuals, and that one of the forces that had tried to stop that was a civilian defense force developed by the person who was essentially the government's later Minister of Justice, or Minister of Defense. But in the course of resisting that, his forces committed mass atrocities and targeted communities for complete killing, even when they were just on the grounds that those communities were perhaps rebel supporters. David Crane chose to prosecute essentially the man who was Minister of Defense of Sierra Leone and to arrest him in his ministry in 2003. And we carried forward with that prosecution, a very controversial one. Sadly, that particular individual died just before the entry of judgment, but his two co-accused were convicted, and those convictions were upheld and the sentences lengthened. These are the challenges that international justice faces in the wake of the perception at Katyn that people who committed grave crimes, and there's no question that the crime of Katyn justifies international prosecution, didn't happen. Now, as we look at the world, we deal with the question of how to go forward, what kind of policy to push, how to accomplish justice. And I think what we've seen is that with Nuremberg, with these other tribunals whose work is ongoing, and some are closing, with the establishment of the ICC, now with 113 members, though not the United States, there has been created an expectation of justice, that there needs to be accountability. And even though it doesn't happen everywhere, even though in some places the butchers face consequences, in other places it's impossible to bring them to justice, what we've done is create the expectation that there should be justice. And so everywhere you go, people are saying, is our blood not red? Do our victims of mass atrocity not deserve justice? I've just finished, and I travel 70% of the time in this job, and I just came back from a 31,000-mile trip around the world, dealing with situations old and new. In Bangladesh, A tribunal is being established to try the crimes of 1971. 3 million people, according to the allegations, killed, generally on a political and ethnic and religious basis, during the 1971 War of Independence by forces allied with West Pakistan. I was in Cambodia, where in July, I was there earlier, the person who ran the execution, the torture and execution camp, often called Commander Doik, which brought 15,000 people in, forced them under torture to confess. All those people died, were executed with pipes crushing their skull. Only 11 survived. He was convicted of genocide, or convicted of crimes against humanity and war crimes. And in June, trials of the 4 surviving leaders of the Pol Pot regime, including the chief of state, including the foreign minister, including the minister of social welfare, and brother number 2, the second person to Pol Pot. They're between the ages of 78 and 85, will begin in Phnom Penh before an internationalized court. I was in Kyrgyzstan, where we've established now an international commission of inquiry that finished its work dealing with the atrocious killing of 400 people in June of 2010, ethnic violence between Kyrgyz and Uzbek communities. I was on the border of Burma for 3 days, talking to the Karen and the Shan and the Chin and the Kachin about the murder of thousands, the cold-blooded, full-cut policy of the Burma government that has sent 2 million people into exile, and pressing for a commission of inquiry. So everywhere where we can, where we have living victims and living witnesses and living accused, we're trying to establish a way to find out the truth and to have justice. The challenge, of course, is all of this creates the expectation that for those situations where there are few, if any, living victims, living direct victims, though later generations certainly suffer, and accused have gone beyond the age when they can sit in the dock, how to establish justice. We've heard Congresswoman Kaptur's ideas about the crimes of Katyn, and I'm very proud to be here with you and look forward in the situation of that great crime and others that continue to affect the living, continue to signal injustice to the victims, that we can find a way to establish the truth, identify all of those who suffered and those who were responsible. Thank you very much.
Stephen's going to be on a panel later, so you'll have a chance to ask him questions as well. We're going to start our next panel in just 5 minutes, but it probably is a good idea after lunch for people to take a brief break, and if you want to take your food and get it out from in front of you, you can dump them in the garbage cans outside. See you in 5 minutes.